Welcome to Regulatory Horizons, delivering strategic insights for the future of global life sciences regulation. This podcast is your guide to the evolving policies, global frameworks, and innovations shaping the compliance landscape across biotech, pharma, medical devices, and even foods. I'm Amy Kottman, and you're listening to Baker Hosts. The BIOSECURE Act is now law, and the life sciences companies across the supply chain are suddenly facing existential questions about their vendors, data flows, and federal contracting eligibility. What is changing? When? And what should companies be doing now? Today on Regulatory Horizons, we address the what, when, and why. Let's listen in.
Hello, friends. My name is Winston Curtin, and I'm the leader of Baker Hostetler's FDA practice and co-leader of the firm's life sciences industry team and the host of the Regulatory Horizons podcast. Today's topic is a big one, the BIOSECURE Act, signed into law on December 18, 2025, as part of the fiscal year 2026 National Defense Authorization Act. The law restricts federal agencies, contractors, and grant recipients from procuring or using biotechnology equipment or services from what the statute calls biotechnology companies of concern. This is more than a procurement rule. It has broad implications for biopharma, medical device companies, CDMOs, CROs, genomic companies, and even research institutions relying on federal funds. Implementation timelines, designations, and compliance obligations are already starting to take shape. Today, I'm happy to be joined by my federal policy colleague, Adam Higgins, here in Washington, D.C. Adam began his career on Capitol Hill, including legislative work covering a variety of topics. And since then, he has spent more than a decade advising companies and advocating for their policy goals. Although he has worked with organizations in a variety of industries, his focus is on healthcare and life sciences, and he has advised companies ranging from clinical stage biotech startups to Fortune 500 corporations. Welcome to the Regulatory Horizons podcast, Adam.
Thanks for having me, Winston. Glad to be with you.
Wonderful. Let's jump right in. So, Adam, at a high level, can you explain to our audience what the BIOSECURE Act does?
Sure. First, let me just set the context and process a little bit, because I think it is important. So you mentioned that BIOSECURE passed as part of the annual defense policy bill, but this is a product of the House China Committee, the Select Committee on the Chinese Communist Party. And that committee was stood up about 3 years ago because of the growing bipartisan concern around the CCP and the threats that it poses. And this committee has quietly been one of the most functional and effective organs of Congress over the past couple years, despite the fact that they do not have original legislative jurisdiction like most standing committees, meaning the China Committee cannot take up and pass legislation on its own. They make recommendations that the other standing committees can then take up and pass ultimately into law. And they've done that with the TikTok ban legislation and now with BIOSECURE. And they really persevered and took several attempts on BIOSECURE. Looked like it was going to be part of the NDAA 2 years ago, and then it fell out over some due process and some other concerns from both members and industry. So really an impressive array of lawmakers and what they're doing. There are disagreements, but they don't devolve into partisan bickering, and ultimately they're trying to get to policy results. And so BIOSECURE addresses a specific concern that was raised within the committee, which is the CCP using its affiliated companies to collect genetic data from Americans and other people around the world, and with the concern that it could be used for malign intent, perhaps even something like a bioweapon. These were the concerns that were raised within the committee. And that's on top of all of the concerns around the usual CCB playbook, where they use their affiliated entities and companies to, quote unquote, partner with American companies, steal their IP, and ultimately put them out of business and grow the CCP aligned industry in China. Biotech being one of the areas that they want to really dominate or occupy the heights, in the language that Xi Jinping has used. So that's the context. At a high level, to address those concerns, what the law does is creates a federal prohibition so that executive agencies cannot enter into or renew or extend a contract with any entity that uses biotechnology equipment or services from a biotechnology company of concern. That's the sort of term of art, so to speak, that was created in the law in the performance of the federal contract. It also applies a similar prohibition to federal grant or loan funds being used to procure equipment or services from those companies. Now, I mentioned some of the concerns that had been raised and addressed previously. So, unlike previous versions, the version that was passed into law does not list specific companies like WuXi AppTec or WuXi Biologics by name. Instead, it creates two pathways for designation as a biotechnology company of concern. The first is the 1260H process. That was created in 2021, I believe, also within the NDAA to identify the Chinese military companies that are operating in the U.S., some of which are involved in biotech. That's a Defense Department list. And then the BIOSECURE law also creates a process within the Office of Management and Budget at the White House where OMB can determine that an entity is controlled by a foreign adversary, that being the CCP, but it doesn't have to just be China. It could be North Korea, Russia, Iran, any of these foreign adversaries. So controlled by a foreign adversary and involved in biotech equipment and services and poses a national security risk. OMB is going to publish the initial list within 1 year of enactment, so effectively within this calendar year, and then update it on an annual basis.
Wonderful. Thank you so much for the frame and the background. I think that's very important. Why should pharmaceutical manufacturers and medical device companies and gene sequencing companies and even clinical research organizations and contract manufacturers be paying very close attention to all of this?
Sure. You have to be paying attention to the implementation of this. There's three key reasons. The first is the most obvious. The exposure within your supply chain could jeopardize your eligibility for federal contracts. Even a single piece of equipment from a company that's designated as a BCC that is used in the performance of a federal contract could make your company ineligible for any federal contracts, grants, loans, etc. And it's not just if your specific company as a contractor uses them. The way the law is written, it's if the performance of the contract will require the use of biotech equipment or services from a company of concern. So it's really, we're anticipating wide-ranging impacts across vendors, contracting structures, and obviously primarily in the life sciences space, but concern even that it could reach more broadly to federal contractors in any number of spaces if there is some nexus in their supply chain, say could be software, to a company of concern. Second, federal contracts and reimbursement pathways are frequently intertwined. So medical product manufacturers, pharma and device, often rely on federal supply schedule, FSS, participation for the reimbursement and contracting with the VA, with Defense Health Agency, even Medicare and Medicaid pricing and reimbursement calculations. Now, the most recent version of the BIOSECURE bill that was ultimately passed into law did include some language to try to address, there was an industry, primarily a pharma industry, concern over the Medicare and Medicaid reimbursement piece that I mentioned. But there's even some uncertainty about how that's going to apply, primarily geared to outpatient drugs under Medicare Part B and Medicaid. So there is that concern still existing that it could touch on those reimbursement pathways in some way. And then the final reason to be paying attention, and not just paying attention, but engaging in Washington, is there is meaningful uncertainty in how this law was written, in how it be implemented and communicated. There's a lot of discretion, as frequently happens with Congress and creating federal law. There's a lot of discretion left to OMB primarily and other federal agencies to implement the law. What is the scope of covered equipment and services? There's a whole list of the types of equipment and services that could be included, but then there's also tremendous discretion left to OMB to include anywhere else that there could be a concern within the supply chain. And then the timing of compliance, and again, as I mentioned, how all of this is going to be communicated to industry and what sort of interaction industry will formally have with the administration as this is being implemented.
Okay. You know that clients, they favor Baker Hostetler because we're known as giving very practical advice and direction, right? So
Sure.
if we are advising, or we were to advise, which we are, life sciences companies around this. So we mentioned the slew of life science company makeup, so pharmas, biotechs, device platforms, or sequencing companies. What's the short list of steps they should take now before the biotechnology companies list is published?
Sure. So I think there's a list of specific steps they ought to take. But I think more generally speaking, as I mentioned a moment ago, you need to be engaging right now with Capitol Hill and with the administration. As Winston mentioned, we're happy to help with that and advise on that, or whether it's a company has their own federal relations team here in Washington, or perhaps through their trade associations. I know Bio was heavily involved in the drafting and weighing in with some concerns about the legislation itself. So working through your trade associations to engage and make sure that your concerns and your perspective is included. Just because the law has passed, it's not too late to communicate your specific situation and concerns, both to Capitol Hill and to the administration. So as far as the specific steps that companies should be taking now, first is just to map your supply chain. And it sounds simple, but it's obviously very complicated. Your supply chain and your service providers, and work to identify any reliance on equipment, sequencing platforms, genomics tools, cloud services, or other software or data processing from entities that might fall under the 1260H list or the criteria that OMB will be creating. And again, this is not just your own company, but that will be used in the performance of a contract. And engage early in discussions with your vendors. Even before this list is published by OMB, companies need to begin assessing their exposure and perhaps exploring alternative vendors and redundancy. The consensus that we've heard is that early planning is essential here because there are going to be some long-term impacts on your vendors, contract structures, and compliance. Categorize any contracts that you have currently with the federal government that involve federal funds, anything relying on funding from NIH, the Defense Department, BARDA, CMS, VA, NSF, or other federal agencies will be impacted here. And then the contract amendments that are going to be required, I think, Winston, you're the attorney here. I'm not. So I think this is something where you'll be doing a lot of work, and I imagine already are, with folks as they're preparing their contracting structures to certify non-use of covered equipment or services. And then going forward, continuing to monitor not just this initial list that will be coming out from OMB, but then it'll be updated annually, as we mentioned. So this list is going to evolve, and it's not just going to be a one-time adjustment that companies will have to make. It's going to be an ongoing process. And importantly, and tying back to the context that I initially mentioned, there will be changes in politics, there will be changes in administrations, and maybe that will change around the margins how this is implemented. But there is this growing hawkishness around the CCP in Washington that I see really with both sides of the aisle, Republicans and Democrats, with elected leaders and with the policy advisors who are helping them to craft their policy initiatives. We typically think of Republicans as being the more hawkish on foreign relations generally, and especially with regards to the CCP. But this has really become a bipartisan area of concern. I think about Congressman Raja Krishnamurthy from Chicago, who is the ranking Democrat on the House China Committee, probably going to be the next senator from the state of Illinois. He is a China hawk and does a remarkable job of laying out the playbook that I mentioned earlier for CCP-aligned companies to steal IP from American companies and ultimately move forward with that. So this is a real bipartisan area of concern that is not going away.
Yeah, no, it's great that you emphasize the bipartisanism, right? Because this is something that we saw way back, even before the change of administration, right? This BIOSECURE Act was receiving support from both sides of the aisle, right? Quite frankly. And this is why it hasn't disappeared. Obviously, you have mentioned there was some negotiation and names have come out, but it is and will continue to receive bipartisan support. The other thing here is the 3 Ps, right? Prepare, and prepare, right? So you can't prepare enough in this. And I do think companies that have some of these concerns can do themselves the best favor, if you will, by preparing, by engaging, as you mentioned. Listen, before we land the plane, I want to throw some practical scenarios at you and get your impact assessment, if you will, based upon some of the companies or the life sciences interests that we spoke about earlier, if that's okay with you.
Absolutely. Let's do it.
All right. Impact to a U.S. drug manufacturer using a CDMO in China.
So this is probably the biggest concern that I heard as BIOSECURE was being put together and moving through the process over the past couple years, with the concentration of the contract development and research and manufacturing in China. There is a lot of exposure there, and at least some of those companies in China that American drug companies use are likely to be designated as biotechnology companies of concern that could be faced with that choice where continuing to work with those companies in China could jeopardize a manufacturer's ability to work on federally funded programs.
Okay.
This also, I think, could have a secondary result, potentially, of growth in the contract development and manufacturing space outside of China, perhaps in the US, perhaps elsewhere around the world. So perhaps there are opportunities there as well.
That's wonderful. We like to give the balanced view, right? This is not intended to scare companies, right? And so there is always opportunities when anything new is put in place that may create some level of uncertainty. All right, next scenario or hypothetical. What about a device company supplying the VA?
Sure. So have to make sure that no part of the supply chain involves restricted inputs from a BCC in order to continue supplying the VA and other federal agencies. But think about this, for both drugs and devices, your FDA approvals are oftentimes tied to specific manufacturing process. So this isn't necessarily as simple as just subbing out one supplier or one piece of equipment for another. The question around is the product, the device in question, going to have to go back through the FDA clearance process, which could take, depending on the technology or the drug, a matter of years.
Yeah, that's a really good point. That's a really good point. You don't get to pause and pick up where you left off, right? You have to start back from the beginning, which could present some significant challenges, especially for smaller co's that are trying to make their way through and get products onto the market. All right, last one, which is a layup. What about a university lab receiving NIH grants?
Sure. So, of course, as a grant recipient, you need to confirm that any equipment that you're using in the performance of that research was compliant and not sourced from a company of concern. And I think you said it's a layup, but I think it's important mentioning universities because this isn't just something where only pharmaceutical manufacturers and device manufacturers need to be concerned. As I mentioned at the beginning, this could have wide-ranging impacts throughout all sectors. Again, if there's just that nexus somewhere in the supply chain that performing a federal contract or the work funded by a grant may have a nexus with a biotechnology company of concern in China.
Yeah. A lot to unpack and think about and prepare for. So Adam Higgins, first to you, I'd like to thank you so very much for joining the podcast. And as developments occur, we're going to look forward to having you come back and share insights. And to our audience, I want to remind you that the BIOSECURE Act represents one of the most significant intersections of life sciences and national security policy in years. So if your company is touching federal funds, directly or indirectly, as Adam was clear to point out, it's not just the direct interactions or interface, it's indirect. Now is the time to act, right? So we thank you, our listeners, for tuning in to the Regulatory Horizons podcast. And until next time, I'm Winston Curtin. Stay well.
Thank you, Winston and Adam. If you have any questions for Winston or Adam, their contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Host are those of participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.